All right, everybody, welcome back to Fiegel Files. I'm your host, Beau Fiegel, the strongest lawyer in Texas. Today's episode, we're going to talk about uncontested divorces. So I want to start a new segment. I'm going to do some of these kind of podcasts that are a little shorter, and I want to give people an idea of how different cases work in Texas, give you sort of the flow, give you the technicalities, give you the process, some of the timeline, how it works, what to expect, and maybe clarify some of the questions you would normally have about these kind of cases. So today, like I said, we're going to talk about uncontested divorce. What is it? What's the timeline? What's the process? How do I get one? What can I expect? Let's start with the term. So to be very technical and tedious, there is no such thing as an uncontested divorce technically. When you file for divorce in Texas, it's the same kind of filing, the same petition for divorce. If it's, the world's most nasty contested divorce for a business, estate, kids, custody, third parties, all that, as it is for the quote uncontested simple divorce. It all begins with a petition for divorce. We call it uncontested because when you go to the attorney's office or you're filing or you go into the court, the understanding is both parties want the divorce and both parties have an agreement as to their property and their kids. So we're essentially just doing paperwork and, getting around some of the service and stuff like that. So uncontested isn't technically a thing under the law, but it's the idea that you're going to get divorced by agreement and use a lawyer to guide you through the process, get it done, the paperwork with the court, and get it accomplished. So when you say uncontested divorce, understand you're not actually filing something different. You're still filing a divorce. It's still a legal process. The rules of evidence still apply. The rules of civil procedure still apply. The Texas Family Code still applies, and all that stuff. So how does it work in general? So for uncontested divorces, and again, this will be very similar when I do an episode on, quote, contested divorces, it all begins with a petition for divorce. Somebody's going to be the petitioner. I've never seen or know of any mechanism where you can jointly file as a joint petition for divorce. Maybe there's some obscure way to do that. But if you come to my office or anybody I've ever met in 13 years of practicing, someone will be the petitioner for divorce, and you will file that petition. There are certain requirements that have to be met. Yes, you can find them online and you can find forms online. There's nothing particularly wrong with that. But I would always say hire a lawyer. And actually, we'll start with why to get a lawyer now. Divorces have consequences. They have consequences to your kids. They have consequences to your property, separate property if it came into the divorce, community property during the divorce, and can affect your future financial interest. The agreements you make with your kids affect geographic restrictions. They affect your child support obligations. You can affect during the divorce part, spousal or maintenance or not, alimony or not, how you handle selling the house, the rules on selling the house or splitting equity or refinancing a house, rules on refinancing a car, paying debts. It's immensely complicated. And unless you have proper legal counsel, you will make a mistake. And sincerely, a significant part of my practice is cleaning up mistakes from pro se's who try to do it on their own, attorney general cases where the people didn't understand what they were agreeing to in the attorney general's office, or unfortunately, every once in a while, colleagues of mine who maybe missed something in their divorces or their custody cases. So get good legal counsel, even if you think you're fully agreed, even if you've got everything written down, even if you know what you want from the divorce, you need counsel. The other thing I'll tell you is you don't know what you want out of the divorce if you don't know what the law tells you is right and wrong with regards to our state. So this isn't something to cheap out on. Say, I want an easy divorce. I want a quick one. I want an uncontested. This is the last thing you need to be cheap on. You need to hire counsel. Now, I'm not telling you to go pay someone some 20 grand retainer for a simple agreed divorce. That'd be ridiculous. But pay someone something. The 2,000 to 4,000 range, I think, for an uncontested where it's all written down is appropriate. And as I go through some of these details, I hope you understand why. This isn't just to be self-serving. You can make a lot of mistakes and have a lot of pitfalls if you don't do this correctly. So getting to it, first thing you do is first thing is hire a lawyer, right? First thing we do is file the petition for divorce. So let's just make up the example. The wife has hired the lawyer, and we file the petition for divorce. Now pause. Can an attorney represent both parties? Technically, yes. I won't do it. I think there's too many question marks for professional responsibility. I think it creates too much liability later if the parties later disagree. Essentially, the way I understand the rules would be I can jointly represent you in the divorce to get it done, but the second you disagree, I have to withdraw from both. rather than do that, what I do when people approach me in these kind of situations is say, I will represent you. The other party is going to be unrepresented. They can trust me or not. The best version is they hire your lawyer, you hire a lawyer. And again, the problem is, and I know you get the wrong lawyer and everybody runs up bills. There's no easy way out of this. And I'm sorry for that. There are gaps in my profession, but the safest way is one person has the lawyer, you trust that lawyer. And if it's truly uncontested and agreed, the other person's taking a risk by not having a lawyer. I think the best is you both do. But you have colleagues that aren't looking to just bleed you for money. They genuinely are trying to take care of you in your best interest. So anyway, a little bit of a sidebar, but how we do it is, let's say the wife with the kids approaches me. My husband and I are getting divorced. We agree on everything. We need it written up. So the first thing we do is we file the petition for divorce. Now, that starts a 60-day clock. In Texas, you cannot be divorced within 60 days with very few exceptions, and they don't apply to uncontested divorces. We're talking some family violence stuff and some other that's not obscure, but there are very few ways to waive the 60-day requirement. None of them would apply to an uncontested divorce. So a 60-day clock starts once you file the divorce. Not serve it, file it. So you want to file that pretty quick, and you're going to file the petition. The petition can be quite basic. It can just say, the name, the style of the case, the names of the parties and the kids, the rationale for the divorce, which for uncontested will almost for sure be something called insupportability. I'll get there in a minute. File the petition, and that starts your 60-day clock. The contents of the petition, there are requirements in the Texas Family Code for what they are. I'm not going to list each one, but you could find them online. You can file them in the Texas Family Practice Manual or the online forms people use to file pro se divorces. Again, trust a lawyer to do this, but that's how you do that. The petition will allege who's the petitioner, who's the respondent. It will allege who the kids are. It'll allege the grounds for the divorce. It'll go through what kind of property division you want, and it can go through what we want for the kids. The petition can be as basic as we'll come to an agreement on property, or you want a just and right or a division of property from the court. It can be one sentence. And with the kids, we want all orders in the best interest of the kids. The petition doesn't have to be immensely complicated or mention everything. It won't mention specifics outside of the names of the parties and the kids, but it does open the door and start that 60-day clock so you can get divorced after the expiration of 60 days. So important to get that on file pretty quick because that'll start your clock when you can finish. And in an uncontested divorce, oftentimes time, I won't say it's of the essence, but it doesn't make much sense to have these divorces linger if you guys are in agreement. So what do we do when the petition's filed? You have to serve the other party. Now in a contested setting, that makes sense, right? You get the lawsuit, you file the process server or the sheriff or the constable, you knock on the door, or you trick them and are you such and such? And you've been served. Gotcha. Okay. Well, when it's uncontested, obviously, you guys are in agreement. So what I typically do is I email that filed petition once it gets stamped by the court, email it to the other party, but you still have to effectuate or show service. So how do we do that in an uncontested divorce? You draft and file a document called a waiver of service. So the petitioner is filed, the respondent needs to either be served or they need to waive service. So what that means is they sign a document, which again, there are rules for how this document works. They sign that document saying, I have received the petition and I waive service of process. Now, again, get a lawyer because those documents can be sneaky. There's a term we throw around in family law called a dirty waiver, because sometimes those waivers don't just say, I received the petition. Sometimes they say, I waive my right to all future hearings. You can sign anything without my permission. They exist. And I've seen colleagues of mine have who do the quote uncontested. They'll file the petition. They'll email a packet with the petition and the waiver to the other side and a decree, and then they'll sign it and then they'll enter whatever divorce decree they want as favorable to their client as possible. And the recourse is limited because you signed that dirty waiver. So again, get a lawyer, but that's the next step. So you file the petition, then you file the waiver that's been executed by the other side. Now, here we go. Now, as far as rules with the waiver, the only quirky rule with it is one's got to be sworn to. You can use what's called an unsworn declaration. I prefer an actual jurat with a notary. It's just safer. Almost all law offices have notaries. Banks will often have notaries. UPS stores have notaries. They have traveling notaries. My office has a notary, like my paralegal has one. Any paralegal I've ever had, we have them go through the training because plenty of our documents need notarization. So it just makes sense. It's got to be sworn to, got to be notarized, got to be filed. And before you can finalize your divorce, that waiver of service or proof of service actually has to be on file with the court for 10 days. A lot of people don't know that rule, and I've actually seen courts not implement that rule, but it is a law. Let's follow it. You don't want, there's no reason to go outside the law and go contest a divorce. Don't ever go outside the law. Yeah, let's not ever do that. But I'm saying there's no reason to try to find some quirk. Just do this the right way. You've got time. If it's uncontested, there's no pressure. Just get it done. Okay, so let's say it's done. We've got a petition filed. We've got a waiver of service done. Now, what do we do next? Well, the last step is you have to have a decree and get it proved up. So let's go through the contents of the decree. Let's assume there's kids. Divorce decrees have to have a number of things. And again, this is where I think the attorney's work really comes into play. When it comes to property division, now you're going to say, I don't have any assets. Well, you might have a small retirement, or you have a car. Maybe both your names are on the car, and you've got to deal with the transfer of title, and you might have to deal with refinancing. If the divorce decree doesn't have that, let's imagine, in my scenario, the wife with the kids, they just bought a nice, a big SUV, some $120,000 Cadillac, Escalade for the kids. There's 6 years left on the note, both their names on it. She wants to keep it. She says, I'll make the payments. Sure. So if I wrote the decree that said she gets to keep the car and she agrees to pay the debts and dad just sits on it, well, I've made a mistake, because what's happened now is he has no remedy under that decree to force her to sell the car if she doesn't make the payments, or to force her to refinance. You have to think about those things when you do this. And again, hire counsel. I can't stress that enough. When it comes to real estate, this happens a lot. The mom will be like, I want to stay in the house, and dad's on a loan for 20 more years. And you're like, okay, but not only does he need to get his equity out of the house, which requires either you to refinance, pay him cash, or sell the thing. The other part is his name is tied up in the note. Divorces do not force banks or lending companies with credit cards, vehicle loans, or mortgages to change who they go after for the loans. You can't divorce your way out of debt. It doesn't work that way. So you have to handle that. So if both your names are on the mortgage, you have to handle that. So when it comes to property division, you say you don't have assets, and a lot of people don't, that's okay. But even vehicles, retirements, no matter how small they are, or mortgages, all have issues that need to be addressed very specifically. And you need to walk through that with your attorney and know what you're talking about. And, I've encountered a lot of people who, and this is no judgment. You don't have a lot of financial sophistication. And why would you, right? You get married, you're assuming you're with this person forever. You buy a house together. You're not planning to get divorced. And I'm not someone who thinks you should. That's a existential, a philosophical question, a religious or a moral one. I personally am naive to the idea you get married, live your life to the fullest with that partner. And if it breaks up, that's where I come in to do my best to protect you. But I think I struggle with the idea, let's live our marriage in anticipation of divorce. That's an opinion. Hit me up in the comments. Do you? That's fine. But for me, let's live our marriages to the fullest. So I don't judge people for not having major financial sophistication or understanding exactly how mortgages work, or refinances work, or real estate works, or 401ks work, or 529s. That's not your job. It is to a degree when you're planning your finances, but don't let your lack of knowledge, or don't let your lack of appreciation for your lack of knowledge make you make really bad decisions when it comes to the divorce. So when you do property division, everything's got to be divided. Now, you don't have to split every item. A lot of times what we do is the parties have already moved out, and you keep the stuff in your house, you keep the stuff in your house, you keep your bank account, you keep your bank account. But you do have to look at what's joint. Oftentimes credit cards are joint, and this person gets this credit card or this credit card. Anything that you agree to can usually be handled, but you do want to know what you're agreeing to. So, and remember, you've got to deal with it. Let's say you don't. Let's say you do the divorce, say you're divorced, and you never mention the real estate. There actually is a separate lawsuit called, a post-divorce separation of property lawsuit. It's called something else, but that's what you're doing, post-dissolution property separation. And the court will have to divide that property again because it's community property that wasn't divided during the divorce. So you want it handled correctly. And again, these nuances are problematic. I have had cases where the parties didn't have in the divorce decree, where the party who retained the house, any language that forced that party to sell or refinance, even if they default, and hurt the credit of the person who's still on the loan. And because that language isn't in there, the person that wants to get that off their credit has no legal remedy. They get to sit back And imagine trying to get a loan for a new house if you're stuck on that loan for the next 20 years and that person's not making payments. That can be a problem. So you really want to address this correctly. This will go to the contested divorce stuff too. So that property division needs to be written out. When it comes to kids, you're going to be required to deal with 5 areas of law when it comes to the kids. 5 categories need to be dealt with. Conservatorship, possession and access, child support, medical support, and dental support. Short version for the last 2, the kids have to be insured, whether that's state insurance like Medicaid or CHIP, or privately insured, and someone's either reimbursing the other party or someone's just carrying the insurance. You guys can agree to whatever you want. The state insurance gets complicated because when the parties split, the state no longer just magically pays the health insurance for you. The state demands that a non-custodial parent pay the state back an amount for Medicaid or CHIP. And I have my opinion about that. I think they should just provide aid, but my opinion doesn't really go very far. The reality is that's the law and that's what's going to happen. And I'll also hurt a lot of feelings here. The Attorney General's office, when they're doing child support stuff, that's really most of their job. Is they get a lot of case referrals because they see people living in different houses doing Medicaid, and they want to make sure they're getting reimbursement for the Medicaid. As a sidebar, the Attorney General does not work for moms, does not work for dads, does not work for kids. They work for the Attorney General's office, and they work for the Attorney General's office interest, which is collecting Medicaid payments, showing politically that they collect child support payments, and running their numbers and getting their numbers met. That is not a disparagement of my colleagues in the Attorney General's office. I know great colleagues of mine, men and women, who do really care and do their job well. But at the end of the day, their job is to represent the state of Texas. They do not represent a party. And I think the problem is the office, not my colleagues in the office, but the office itself tends to promote itself as, we'll help you get child support, we'll establish custody and stuff. They need to get out of the business of that there. I could do a whole podcast on how problematic that office makes things, but again, it's not my colleagues, it's the law and how it's integrated. So we'll table that for another time. But you do have to handle the medical and you do have to handle the dental insurance. And again, there's forms for that. There's specific laws for that. Again, a lawyer can guide you through. I'll skip child support for a second, but essentially you have to deal with it. Whether no one's paying child support, but you have to do it correctly. You can do it on who pays who. You pay an offset. You pay this. You don't have to follow the code in an uncontested divorce on how much it is or follow a guideline number, but you do have to know whether you're going to have child support, how much it is, and have the amount, the method of payment, how frequent, the dates of payment that has to be outlined in the divorce decree correctly. And then you have to go through the Attorney General's office because that's the law itself. So, and there's even some nuance to that. So you have to deal with those 3 issues. The big boy issues, though, not that money's not important or insurance or child support, but the big boy issues are conservatorship and possession and access. Possession and access is exactly as it sounds. It is what is the schedule with the kids between the parties? This is harder than you think because the language of the decree needs to be what's called enforceable. You have to have the schedule spelled out and the parties' duties on who drives, picks up when so clear as to be able to be enforceable by contempt, which means it has to be so obvious on the sheet of paper what your job was or what the schedule was that if you deny that schedule, the other person can sue you for contempt and make up time and attorney's fees and such. If it's vague, you don't have a remedy. So if, my little scenario here, I've got mom with the kids and she says, I want a decree that says dad can see the kids whenever I let him. That's not enforceable because you'll just say you never let him. Dad needs a schedule. Well, dad can have them 20 days out of the year. Well, how does he get his 20 days? Does he pick? Does he give you notice? I hope you can start to see the problem here. You need to have the schedule or the rules around the schedule clearly delineated. And the more modified from the standard possession order you make the schedule, the harder it is to write to make it enforceable. And again, get an attorney to write this for you because at the worst case, you can blame them when it goes south. But you want someone who competently understands how this works so you can have enforceable language for that possession and access. I can't imagine a more fundamentally important part of this because kids need to see both parents, and one parent shouldn't get over on the other because the decree was written poorly. The final step of the suit affecting parent-child relationship, meaning the kid or the custody part of your divorce, is conservatorship, which is a fancy word for decision-making authority. There are 11 rights and duties spelled out by the Texas Family Code, which include like medical, invasive medical, psychological, psychiatric, education, right to earnings of the child. There's a bunch. Are these decisions going to be made by one party? Are some by one or the other? Are they exclusive rights to someone? Are they joint rights to someone? Do you need joint agreement? Do you need independent rights? Like while the kids are with this party, they can make the decisions. While they're with this party, they make the decisions. That all has to be spelled out. And again, you've got forms you can check the boxes, but if you read that closer, it's a lot more complex than you think, and you may not know the implications. Under the conservatorship umbrella, there's something we have called a geographic restriction. Where can the kids live? Maybe there's a primary parent and you're not doing 50-50. Well, that primary parent has to keep the kids within a specific geo zone. Maybe you agree to no geo. You got to know what the implications of that are. Maybe you do. Maybe child support changes if you lift the geo. Maybe someone's military. Maybe someone's not. You've got to deal with this stuff when you do that. So you've got to deal with conservatorship, possession and access, child support, medical support, dental support, along with the property division. Now, some less, they're important in other types of divorces, but you also have to have the rationale for divorce. The Texas word for no fault is called insupportability, which is basically you can't get along anymore. The legitimate ends of the marital relationship are no longer being met, is the fancy way to say it. And you have to show there's no likely hope of reconciliation. All you have to do is say that to a judge and they'll grant it. But that's the code. That's why the court grants a divorce is you guys can no longer be married anymore. The legitimate ends of the relationship are destroyed for whatever reason. You can't get along, someone cheated, I don't know, whatever the rationale is for people to get divorced. So you got to have that in there. You got to have the parties. So here's where we're at. We got a petition filed. We got a waiver from the other party. We've got a decree written and we agree on the decree. Everybody signed it. What's next? And 60 days have elapsed and the waiver of service has been in file for 10 days. All right, we've got it all done. We're happy with our decree. We know what our rights and duties are. We know who's got to sign what document for property. We know who has to refi or not. We know the schedule for the kids. We've got our decree. We're ready to go. What's the last step? Let's assume 60 days have elapsed and the waiver's been in file 10 days. Now you've got to get a judge to sign it. Now, divorces are quirky because they're one of a few areas in the law where you still have to prove up the divorce to a court. A lot of agreed judgments in a lot of cases, you actually can just give the judge the paper to sign. They can sign it. That's it. It's not the case with the divorces. You actually have to go before a judge in one way or the other to answer certain questions before a judge, so the judge has the authority or the jurisdiction to grant the divorce. Now, the way I handle this with agreed or uncontested divorces is I draft an affidavit that's executed by my client or the other client or the other party, that answers those questions for them. The questions are jurisdictional. It's have you lived in Texas prior to filing a divorce? Did you live in Texas for 6 months? Bear County, where I live, 90 days. Are you getting divorced on the grounds of insupportability? Are you pregnant? Because you can't get divorced if you're currently pregnant or there's a kid that's outside of the marriage without dealing with that in a different way. Is the property division just as right? Are the children provisions, in the best interest of the children? You've got to answer these questions. You can't get divorced if you're currently in bankruptcy, either one of you, without a stay from the bankruptcy court. So you've got to ask those questions to allow the judge the authority. How do you get in front of the judge? It's different in every county. And will the judges grant it? It's actually different in every county. Nowadays, I haven't seen a rural county deny a divorce because they want you to go to counseling or anything. I've seen that before. I was in a smaller county early in my career, and the judge was up there with all the paperwork done correct. Like, are you sure you can reconcile? And you really don't want to go to counseling? And I don't know. I don't feel like that's a judge's place, but who am I to tell people their religious beliefs? But whatever. That doesn't really happen anymore. But I will tell you this. There are judges that scrutinize those decrees. And if it's out of whack and someone's getting treated real unfairly, they might look at you with some side eyes. So again, another reason to have an attorney, because in my experience, typically I don't get scrutinized to the level the clients do, because there's a trust built up with and a rapport built up with me in the court. So every county has their own rules. You are allowed to set a hearing for divorce on your own, a motion with the court, but you got to follow the local rules. In my county and a lot of other counties, we have a judge that's typically available most of the business days, and we just approach that judge, whether remotely or in person, and give them our affidavit of prove up, or have our client there to answer the questions for divorce, and they sign it right there. There's all kinds of ways. Again, every jurisdiction's different, every court's different, but then you prove it up. So that's how you do it, is you present the decree to a judge, either with your client or with yourself, or with an affidavit with the right questions asked. The judge now has had the divorce proved up to them, and now they can grant the divorce, sign the decree. and you're done. Great, right? So we've got our petition, we've got our waiver, we've got our decree signed. Now what? Well, it depends what the decree does. If there's no kids and no child support, you're done. You take a copy, you go home, you're divorced. You can't get remarried within 30 days. And if you want to fix something, you've got 30 days to file to fix it. So make sure you have it right the first time, because that 30 days goes by like that. So you want to be careful. That's pretty much it. That's where it stops. Again, anything that needs to be done as a result, whether there's deeds that need to be exchanged, powers of attorney to transfer title for motor vehicles, or you need to send that order to the Attorney General's office in order to get child support started on a wage withholding, it depends on the case. But that's essentially the uncontested route. So the recap: petition, waiver, decree, affidavit of prove up, 60 days on the petition, 10 days on the waiver, and you got to get yourself in front of that judge, and that depends on the local rules. Like I said, the thing I can't stress, that I have to stress the most is you really want an attorney to walk you through this. I know it sounds self-serving. That's what I do for a living. Like, Beau, you just want to get yourself paid. Well, sure. I mean, business is always good, but, and making money is not a problem. That's not something I'm going to object to, but that's not really it. I promise it's far more lucrative for me for you to mess that divorce up and now pay me many thousands to go try to undo or try to find some back channel way to get you the relief you want when you could have just done it the right way in the first time. So that's it. That's uncontested divorces. I'm going to be doing different episodes like this about guardianships, about contested divorces, custody, modifications, and even some criminal cases and trials and juries and such. So I like the idea of that. You like me scratching my nose? That's funny. So it was an itch. I don't know if y'all watch Seinfeld. It was a scratch and not a pick. So y'all are welcome. But yeah, thank you. I want to wish everybody a belated Merry Christmas and Happy New Year. Thank you so much for the support. In the coming weeks, I will have a professional MMA fighter, a sitting district judge, and an owner of Heavy Metal Fitness coming on my program. So, and an owner of some other gyms too. So I'm excited for the new year. I'm excited for 2026. Big things happening for Fiegel Law. Me and my personal strongman journey. I've got some goals. I'm competing in a show called Winter Wrecker on February 28th. I'm competing in Texas Strongest Man on April 11th. Prep's going great. Diet's a little more on point. I've got some goals I'm doing to meet, some fitness goals and some cardio goals. I mean, I just can't be more grateful. So life's pretty good. The last thing I want to talk about is I would encourage people to do this right before the new year started, and it's not too late. It's already started, is to make yourself a list of goals for 2026. My strongman coach encouraged me to do that, and I do that for both life, business, and strongman. But do it for yourself. And I've done this this is the third year, and I've met them sometimes, I haven't. But what I do is I write them on my notes app, and then I print out a copy, and I actually tape that to the back of my cell phone. And so everywhere I go, I have the goals I want to meet for 2026. I won't share all of them, but my goals that I will share is I said read 20 books. I'm going to make that, try to read 30 books this calendar year. I have a dollar figure I want to save for my family. I have specific business goals I want to meet with the way I do my office. I'd like to deadlift 800 pounds. There's some competitions I want to qualify for, and I'd like to win Texas Strongest Master this year. So that's some of them for me. I've got some more personal ones that I'm not going to share with the whole airwaves, but I want to encourage you to do that for yourself. It's a great way, I think, to start the year fresh and, give yourself an opportunity to challenge yourself to be a better version of you. Even the exercise of setting the goals, kind of put some life in perspective of, what are we doing this year? Are we just getting by, or are we trying to make something happen? Whether it's in your personal life, your relationships with your kids, your relationship with your spouse partner, in your business life, your financial life, or, your physical, what goals do you want to meet physically this year? Never too old to start that. I got a friend, Pastor Rob, who's 50 and right there next to me competing in strongman and killing it. So don't act like you're too old to do physical goals as well. So like I said, guys, Merry Christmas, Happy New Year. Thank you so much for the support for those who listen. I wish you all the best. I'm excited for 2026, and I hope you enjoy the next episode. That's Fiegel Files. Thank you for listening. Make sure you hit like or subscribe to not miss any of the content. Hit me up on Instagram, TikTok, Facebook, and the rest. If you need a divorce or you need any legal help, hit me up at divorcelawyersa.com, or click the link. Hit me up on any of those apps. I can find you. I'm not hard to find. I'm down here in Helotes in San Antonio, Texas. Anyway, stay strong, go Tigers, and I'll see you next week.